you do not have rights, which is worldwide, is it fair to expect that your rights are exhausted worldwide? I mean, that's a question which I pose for the audience and the panelists to examine. That's one. If I have to register my patent or a trademark in India, though I am based in US, in order to enforce, then how my rights are exhausted, which I have arising from my US patent, but there is no patent or trademark in India, how that right is exhausted unless I have a patent also here. And if I have a patent here, then it should only be exhausted by my release of goods in this country, or apply in the case of a trademark by release of the goods in this country. How do you enable a brand owner to commercially exploit different markets if you apply international exhaustion? How do you expect a brand owner to have different marketing strategies if you apply the international exhaustion? Now, the argument which I understand which is in favor of international exhaustion is the pricing. But the question is the pricing alone such a determinative factor to justify international exhaustion? Or is it also the public interest that the product which is coming at a reasonable price does also have a warranty, it also has a quality control, it also has an after-sale service, and if pricing is not the only factor, and if what you require is after-sale service in consumer interest, a quality control in consumer interest, a distribution network in consumer interest, it all involves investment. It all involves setting up a distribution chain, a marketing strategy, an investment in each jurisdiction. And if a brand owner is required to undertake that kind of an investment, then is it fair to say your rights are exhausted in this market? Anybody and everybody is free to import your product and sell it at a much lower price. So it's a complex issue in terms of what is in public interest. Is it international exhaustion or is it a national exhaustion? And that is something which is a matter of policy, which of course the Supreme Court will examine. But at the moment, I'm going to discuss the law as it exists today. So let's look at trademark. Now, trademark, if we read what constitutes infringement, is that it's only a registered proprietor or a permitted user who has a right to use the trademark, which means without authority, nobody else, a distributor, a retailer, a member of a public, is not permitted to sell the product which is registered, which has a registered trademark. When you go to section 29(1)(6)(b), then you will find it says, anyone who offers or exposes goods for sale puts them on the market. Please note, puts them on the market or stocks them for those purposes under the registered trademark or offers or supplies services under the registered trademark, number one. So puts them on the market. Two, imports under the mark, is a person who commits infringement. So I will just go back, if you see section 29, infringement. So putting the product on the market, importing them, unless it's a registered proprietor or a person permitted by the registered proprietor, is an infringement. Now we go to exception as to when it is not an infringement. And the provision which is subject matter of the controversy is section 30, clause 3. Now, I will read it for you for a moment slowly, and I'll explain to you how this is the issue before Supreme Court. So where the goods bearing a registered trademark are lawfully acquired by a person, the sale of goods in the market or otherwise dealing in those goods by that person or by a person claiming under or through him is not an infringement of a trademark. That's an error. It's trademark. It should say trademark. By reason only of, we are not concerned with A, so we go on B. The goods having been put on the market under the registered trademark by the proprietor or with his consent. So, as you saw, and if we read section 30 as it stands, it says where the goods have been put in the market, it is not an infringement. Now, let's pause here. Which market are we talking about? Can it be Germany? Can it be US? Can it be any other market other than India? My understanding is that it refers to Indian market because it says the goods put in the market is not an infringement, has to be in context of the Indian market because but for this section it will be an infringement. Now naturally if somebody puts goods in the market outside India, there is no infringement anyway because the trademark law doesn't extend beyond India, the registration in India doesn't extend beyond India. So when we are talking about exception, we are surely talking about the market which otherwise, but for this section, will constitute infringement. So far no problem. It says where the goods put in the market is not an infringement. The difficulty arises is interpretation of clause B. With the goods having put on the market under the registered trademark by the proprietor or with his consent. Which market is this? Now, the trial judge said, naturally, this market has to be the same market which is referred in clause 3. But for this market, the sale in that market will be an infringement. Or can it be that clause 3 says, putting the goods in the Indian market will not be an infringement. The goods having been put on international market by the registered proprietor or with his consent. And that's the short issue which is going to be decided by the Supreme Court, that can the legislature have intended that when it comes to infringement, market means Indian market, but when it comes to the goods having been put on the market by the registered proprietor, it is market anywhere, which means even outside India. Now, this is the issue which is before the Supreme Court, which is to be decided. Now, what goes in favor of an interpretation that market has to mean Indian market in both the cases, for infringement and for exception, both, is that wherever the legislature intended to use the expression to define a territory which is other than India, it always said in India or outside India. And if therefore the legislative intent was to say in the market in India or outside India, nothing stopped the legislature from adding outside India in clause 3 of section 30. Similarly, in section 56, which talks about the export, the legislature uses the expression done in India or outside India. So these are the examples of the Trademarks Act itself using the expression outside India wherever it intended to do so. There's another example also. So you have 3 sections in the Trademarks Act which use the expression. Now, the question, the Samsung case, as most of you may be aware, which we'll briefly touch, is Samsung printers were imported by third parties. Samsung sued for infringement and said this is an infringement because this is not an authorized import by Samsung. Now, the defendant, which is the Kapil Wadhwa, said, sorry, this is not an infringement because your rights are exhausted. Now, the finding, as you will see here, the trial judge said the market in section 29 and section 30 should mean one and the same market, which is the domestic market. And it said further, the legislatures have specified international market in other section, such as Section 32B, and therefore the omission of international market is conscious intention to limit the market to domestic market, something which appears to be correct, and that's a position even we are taking in amicus brief on behalf of INTA before Supreme Court. The division bench reversed the decision, and it held, and now this is what is very, very interesting. It says, while introducing the trademark bill, so therefore the division bench, the appeal court, went into the objective of the bill, ultimately found itself as Section 30 was explained in the statement of object and reasons inter alia in the following words. And it said, the subclause 3 and 4, you saw subclause 3, recognize the principle of exhaustion of rights by preventing the trademark owner from prohibiting on ground of trademark rights the marketing of goods in any geographical area. This is where the appeal court said this is international exhaustion, because the object and the reasons of the trademark bill had stated any geographical area. Once the goods under the registered trademark are lawfully acquired by a person, when the goods and conditions are changed. So the appeal court has decided that it's international exhaustion purely on the basis of the use of these terms in any geographical area. Now the question is that the reference to any geographical area means what? A geographical area within India, or does it mean geographical area globally? Now, this is something which could be read both ways, to be fair. But when you talk of object and reason, as I understand, which a parliament is laying down, it intends to lay down law which are applicable to its own geographical area. No parliament and no sovereign has a power to legislate about the areas which are beyond the geographical limitation of a nation. And if it refers to a geographical area, should it not be as understood to mean geographical area within India, without any territorial limitation within India? And if it meant to say a geographical area which is anywhere outside India, then perhaps it should have said so, as it did in Section 42, Section 56, Section 57, even Section 30 itself, 4 places in the Act. Wherever it meant to say outside India, it said so. Now, when it doesn't say so outside India in the object and reasons, is it fair on an appeal court to say, I'm going to read geographical area as anywhere? Is something which we believe is not correct, but again, as I said, it's for Supreme Court to decide. Now, of course, there are other grounds on which the international exhaustion, as Samsung appeal court held, can be objected to, which is if the condition of the goods have changed or there are legitimate reasons to oppose further dealing in such goods by the proprietor. There is a difference in the packaging, the quality, or the language, or the services, or the warranty. In such case, the international exhaustion will not disallow or disentitle the proprietor to oppose dealing in such goods. But the question would arise, and I suppose that's what we will be discussing, as to legitimate reasons include only these, or would it also include the privilege which a brand owner has in terms of choosing the market and the territory and appointing different distributors for different territories in different countries, having different terms and conditions for release of goods. And if a US corporation or any overseas corporation has a distributor in India authorized to import the product, then is that a legitimate reason for the brand owner to oppose anybody else from importing the said product in India? Would that constitute a legitimate reason? Is something which I think the panel perhaps can have a view on. Now, plausible interpretations I've already discussed with you, so I will not take time on that.